Yes.
I seek your lordship's indulgence. In respect of part 2, item 6, if this matter may be taken up on Friday, if possible, your lordship. It's a POXO matter.
This week.
This
Okay.
week, this
That
Friday.
both the parties be present.
Yes.
The other side also. Yes.
And also in respect of item number 12, the last item, if the matter may be taken up on Thursday, I've taken the consent of the council for the respondent.
12, Thursday.
Yes,
Okay.
your lordship. Deeply obliged.
My lord, in respect of item number 1, hearing is item number 1. If this may be taken up on tomorrow, I will inform the other council. He has not
Okay,
arrived yet.
during this week, anytime,
lord.
huh? Tuesday, huh? Okay.
Part 2, hearing list, my lord. This matter may be taken today, my lord, because I have taken consent of the other side also. Item 8 today.
Okay. We will call up the matter later, huh?
Regarding item number 3 of part 2, Lord, on behalf of my senior, Mr. Bilaram Menga, if the matter be taken up after 2 weeks,
Why, where is he?
Lord, he's out of station due to family matter.
Have you taken the consent of the other side?
Yes, my Lord, I've taken
Okay.
consent from Miss Mary.
Mention is made on behalf of Mr. B. Lalram Mega, Learned Counsel for the appellant, for adjournment of the matter, since the Learned Counsel is said to be out of station. It is also submitted that consent of the other side has also been taken. In view of the above, list after 2 weeks.
Oblige, my Lord.
My lord, with regards to item number 5, part 2, my lord, I'm on behalf of Mr. Benjamin Lelthamwana, my senior. He is on medical leave today, so if the matter may be taken up after 2 weeks, my lord.
Have you informed
Yes, my lord, we
the
have taken the
appellant?
consent.
Consent taken?
Yes, my lord.
Mention is made on behalf of Mr. Benjamin Lalthamwana, Learned Counsel for respondent number 1 to 6 for adjournment of the matter, since the Learned Counsel is not able to appear due to medical grounds. It is also full stop. It is also submitted that consent of the other side has also been taken. In view of the above, list after 2 weeks.
2 weeks, yes, my lord. Much obliged.
Permission. Item number 1 and 2.
Yes. Yes.
My lord,
Oh,
if the matter may be fixed for hearing, my lord.
this is a contempt matter. So we can hear the matter. You're not prepared today.
Actually, my lord, I missed the file, my lord. This one coming, my lord.
You don't have the file.
Yeah, I took it on my court file, my lord. I took one.
What court file? You don't have your own file.
And I missed my I don't.
So you want another date to be fixed. Is it? Okay, heard Mr. S.K. Mehdi, Learned Counsel for the respondent / NF Railway, who has prayed for adjournment of the matter by submitting that he has not come prepared since the connected files are not available with him. Ms. Valentina Narel Dinpui, Learned Counsel for the petitioner, has not objected to the adjournment of the matter. In view of the above, list is matters
10th of my lord, June, my lord.
on 10th June.
Yes, my lord.
Yes. Anything?
That's a bit too stretched, my
Why?
lord.
What about the month of May? What happened?
My lord,
Fix it sometime during the month of May.
May, my lord.
The second week of May, if possible, my lord. Because it's a matter of hearing.
On 19th of May, my lord. Then.
Okay, list on 19th, 5/20/25 for admission hearing.
Item number 3.
If, my lord,
What?
appeal is pending, my lord. 3, my lord. Item number 3.
Oh, appeal is still pending.
Still pending.
Mr. S.K. Meli, learned counsel for the respondent, submits that the appeal with regards to the judgment and order of this court in
Appeal is, my lord, 3/20 of 2023, my lord.
okay, no, submits that the appeal filed regarding the present subject matter in WA number 320/2023 is still pending in the principal seat. In view of the above, list on same date.
My lord, the appeal is, my lord, fixed on 10th of June, my lord.
What is the stage?
Stage, my lord, on last occasion, matter was listed before principal bench, my lord, on 22nd, my
Or
lord,
for what?
for final hearing, my lord. But,
For filing
final hearing, my lord. Final hearing.
or for final hearing?
Yes, my lord. But due to possible time, my lord, the matter could not reach, my lord. So again, we go on
Is
repair.
pending and submits that though the matter was listed for final hearing before the principal, in the principal seat, okay, on, when was it?
22nd of April, my lord.
22nd April, so and so, the matter could not be heard. He prayed that this matter may be listed during the month of May, is it?
June. My lord, it is fixed on 10th of June, my lord. So, my lord, before that, my lord,
Or during the month of June, accordingly as prayed for, list on
16th June, my lord.
16th June 2025. Miss
Vanaswamy.
Valal Swami, appearing on behalf of the respondents, is present and has raised no objection.
My lord,
We are not the respondent.
I'm respondent, my lord.
Oh, but you're standing on the,
Yes,
this,
yes,
that's why
yes, yes,
learned
yes.
counsel for the petitioner is present and has raised no objection. Yes. And then, in view of the above, list on so and so.
Item numbers 4 to 8.
May it please, Your Lordship.
Yes.
My lord, in this case, as per the latest information available, award was initially passed and approved by the competent authority as per the directions of this honorable court. But subsequently, it was, excuse me, subsequently it was found out that the land value were wrongly calculated, and as such, that award was recalled, and fresh assessment was done by the DC. And
Okay, here it says that new developments had taken place
right. So
to ascertain the amount to be paid to the petitioner.
right. So apparently, in some, not in all the cases, but in some of the cases, some rehabilitation assistance was already paid. That was not deducted in the award. So because of
See, in the last court date, we had noted that the respondents are yet to ascertain the amount still to be paid to the petitioners.
Yes.
By adjusting the amount already received by the petitioners.
So-
some of the petitioners.
some of the
maybe.
petitioners. So this was a verbal submission made by the counsel for the respondent.
So, yes, Mrs. Mary, what are the steps? Have you ascertained the amount to be paid?
Your Worship, the calculation is in process at the moment. No,
Then we'll
nothing
wait
is
for some more
issued.
time?
Yes, my lord. If I
Definitely,
may-
but if some timeline can be given, because the matter is to, the contempt itself is pending from 2019. So
Anyway, I heard Mr. Lal Fakoma. learned counsel for the petitioner, along with Mrs. Mary L. Kiangte, learned government advocate, appearing on behalf of the newly pleaded DC Siha, is it?
My lord.
Arrayed as respondent number?
In the particular, in this case,
12.
12?
My lord.
You see, with all these inclusion, 12 or 11? I think it's 11.
No, 11 is the senior revenue officer in this present item.
16 of 2019.
yes. 12.
Okay.
12, my lord. Impleaded white order dated 3/9/24 passed in
Okay,
IA 150.
arrayed as a respondent, pleaded, okay, as respondent number 12. It is submitted by the learned counsel for the respondent that the calculation as to the amount to be paid to the petitioner is still underway and has prayed for further time. The learned counsel for the new petitioner has brought to the notice of this court that the contempt petition has been pending since 2019 and prayed that a certain time frame may be fixed for the respondents to pay the awarded amount. Having heard the submissions made by the learned counsels for both the parties, this court find it fit to grant further. How long will it take?
Your Lordship, if I may be given another 2 weeks' time, my lord.
Further 2 weeks' time to file their affidavit in compliance. Okay, in compliance. Okay, full stop. Then Miss Baby Larinzwali, learned counsel for respondents
3, 7, and 9.
3, 7, and 9 is present. In view of the above, list after 2 weeks.
Can we have it on the 15th, my lord? That would be 2 weeks from
2
weeks plus 2. 2 days.
on 15th. Is it 15th?
I apologize, Your Lordship. Can it be 16? 15 is a Wednesday.
Okay, on 16th. 16th.
I apologize. I was looking at 24
Which
calendar.
month are you looking at?
I
May,
apologize.
isn't it? We have to look in the month of May.
15, my lord. Yes, 15.
So list on 15th.
My lord.
Yes,
I apologize.
15th 5, 2025. Yes.
Item number,
So item number, this is 4 with 5. Now 5 also, it will be the same order.
My lord, same order, the DC is arrayed as respondent number 15, 1-5.
Okay, so instead of 12, it will be 15 for item number 5. Item number 6?
15, same.
Okay, so 6, 7, and 8, same
in
order?
in item 7, respondent number 14.
Okay. In item number 7, DC Siha will be respondent number 14. What about 8?
Respondent number 10 in item 8.
Okay, 10. Okay, rest will be same. Yes.
Lunch.
item number 9.
Wait, 1 minute. In item number 8, it has been pending since 2021 only, not 2019.
But it's same matter, on the same stretch of road.
So in item number 8, yeah, we will say that you don't mention that it has been pending since 2019. Okay. Yes.
Item number 9.
Lordship, I'm appearing on behalf of my senior, Mr. Bilaram Benga. He's
Out of station.
Yes, my lord. So if the
Who is
matter-
for the respondents? What is the step
Mr.
required to be taken?
For admission hearing, my lord.
Notice complete?
For admission.
Yes, respondents is duly represented in the previous court state but absent today. Mention is made on behalf of Mr. B. Laramenga, learned counsel for the appellant, for adjournment of the matter since the learned counsel is out of station. None appeared for the respondents. In view of the above, just after 2 weeks. Make it none appeared for the respondent, no S, there's only one.
Item number 10.
Yes, Your Lordship. This item is a jail appeal, my lord,
Okay.
and the record has not been received by us.
This is a jail appeal filed by the appellant for setting aside the judgment and sentence order passed by the let's see the judgment. Is it Colossi? Yes, passed by the Fast Track Court, Colossi District, in session case within brackets K number 15/2021, comma, Colossi Excise case number 30/2021, dated 09/04/2024, wherein the accused/appellant was convicted under section 21C of the NDNPS Act and sentenced to suffer rigorous imprisonment for 10 years with a fine of rupees 1 lakh in default RI for a period of 1 year. Full stop. Appeal is admitted. Issue notice to the respondent. Full stop. Ms. Vani Isyami, learned additional PP, accepts notice on behalf of the state respondent. Requisite documents filed in the appeal memo to be duly furnished to the learned government advocate. LCR to be called for. List after 2 weeks. Okay. Meanwhile, this being a jail appeal, the registry is to appoint an amicus curiae to represent the appellant. Yes.
Item number 11.
Again, this is NDNPS, is it? So it will be similar order. Same court, Fast Track Court, Colossi. Date of the judgment is 21/11/2024. Okay. And the case number is session case within brackets K number 25 of 2024. Then Vairengte PS case number 4/2024. Conviction is under section again 21C Terms of imprisonment is 10 years. Fine is 20,000. In default, ID is 3 months. Okay. Rest will the same. Yes.
Item number 12.
Again, jail appeal. Then it will be the same order. Judgment is against the special court, NDNPS, Aizawl Judicial District. Date of judgment is 11/02/2025. Case is Sessions Registration Number 91 of 2022. Reference Excise Case N-16/2022 under Section 22C of the NDNPS Act. Conviction is under Section, most probably 22. Let me see. Oh, yes, 22C of the NDNPS Act. Sentence again 10 years, pay a fine of rupees 1 lakh. In default, 10 months. Okay, rest will be the same. Yes,
Item number 13.
yes.
Yes, in compliance with the order dated 13/3/2025, I have personally served notice to the sole respondent, Your Lordship.
Yes, so is he represented today?
It's not represented as far as my knowledge is concerned. Lordship, the issues are very simple, Your Lordship. That this one is, it was discharged at the stage of consideration of charge, Your Lordship, without taking any evidence.
But he has to be represented. So we'll give him some time, give him a chance.
Yes,
When was notice served to him? Through that
25/4.
25/4. That is
Last
quite
week.
recent, huh?
Last week.
So maybe he still needs time
Yes,
to engage in counsel, isn't it?
yes.
Yes, I heard Mr. Johnny L. Tauchong, learned counsel for the appellant, who submits that notice has been duly served to the respondent through dusty mode, and accordingly, he has filed the affidavit showing that notice was served to the sole respondent on, there's no date here. It is on 1/4/2025, on 01/04/2025. That's now. It is thus seen that notice is served to the sole respondent. However, the respondent is not present, nor is he duly represented. In view of the above, we may await for the respondent to be duly represented. List after 2 weeks.
2 weeks, Lordship.
Item number 14.
Lordship, in this matter, I may be given another 1 week time for filing the Filipino opposition.
This is what? IA is
This is IA,
regarding?
Lordship, yes. There is a delay
Oh,
of
delay of her. So
353
matter
days.
has been kept pending since last year. For you, no.
No, Lordship.
Since when was notice served?
Yes, my lord.
Okay, during the month of
Notice was
March, you had
served.
mentioned that you'll be. I will
December
give you another chance, 300 and something days, isn't it?
Yes,
Yes, Ms. Vani Siami, learned government advocate, is present along with Mr. Johnny L. Tauchong, learned counsel for the respondent. Full stop. The learned counsel for the respondent has prayed for further time to file his written objection. In view of the above, list after 2 weeks.
2 weeks, Lordship, yes.
Obliged.
Item 15.
Please, Your Lordship.
Yes.
AD, as per office note dated 27/3,
Uh,
AD
for
card has,
donation application, is it?
my lord, AD card has come back.
From
Sole
how many respondents?
One,
From the sole respondent?
my lord.
Okay. So are you representing the respondent?
Yes, my lord, we have received instruction and I'll be filing power within 2 days.
Okay. Heard Mr. Alpha Comma, learned counsel for the applicant, who submits that AD card is returned from the sole respondent. Full stop. Then Mr. So-and-so Murmur, learned counsel, submits that he will be representing the sole respondent and prayed for time, and submits that he will be filing his bar
Yes.
within the course of the day.
Within 2 days, my lord.
Okay, will be filing his bar shortly. In view of the above, list the
Ma'am,
matter after,
Your Lordship, if I may, whether they'll be filing any written objections.
yes,
Yes, will be
list the
filing.
matter after 2 weeks for the counsel to file his bar. Thereafter, copy of the IA to be duly furnished to the learned counsel for the sole respondent, who shall file his written objection if any.
Yes.
List after 2 weeks.
Obliged.
Up to item number 8.
Yes.
I plead, Lordship. Oh, this appeal is against my lord. The order got damaged, my lord. This order at 8/12/2022, my lord. This is, my lord. It starts from page 72 of the paper book, my lord. Judgment, my lord.
72 of the paper book.
Yes, my lord.
Yes, the edit, just you can come back later. It might take some time.
My lord, in this judgment is totally depending upon the witness, my lord, court witness, my lord, which was not court examined, my lord, and he was a surveyor, my lord. He was a surveyor, my lord, completely, my lord, my lord, there is a land acquisition process was there, my lord, in the year 2011, my lord. And the judgment speaks, my lord, paragraph 3, my lord, paragraph 3. Defendant number 1 started the land acquisition process, my lord, and my lord, it was 2012 that there was an awardment. At the time, some portion of the land, as per this,
Where is the land situated?
my lord, is Kamrang, my
Oh,
lord.
okay, Bhairavi to Sairang, construction of railway line, okay.
And my lord, praxis that, my lord,
Okay, award in 2012.
12. But their cases, my lord, some portion of the land was acquired, they got compensation, but they subsequently nearby that their land, it was damaged by the number 2, the railway. This is their case, and this is their case. And on this, this defendant number 2, we filed return statement. We filed return statement. The written statement is page 14 of the paper.
Okay, wait, claim of the respondents was that the land was what?
Land was
Damaged.
damaged by the defendant number 2, my lord. I'm reading their prayer. to pass the judgment and decree in favor of the plaintiff against the defendant, and defendant have caused damage to the plaintiff land and crops. B, to pass judgment and decree declaring that each of the plaintiff are entitled to payment of monetary compensation in respect of their respective land and crops damaged by the defendant in the course of their construction of siding railway. C, to pass decree directing the
You're reading from page?
this is page five of this paper book.
Of the paper book. Okay.
Page 5 of the paper book. Your lordship is getting. To pass a decree directing the defendant number 2 to pay monetary compensation after due verification of the extent of damage caused to the respective plaintiff lands and crops as per the norms presently followed by the government of Mizoram in case of compensation. Or to pass judgment and decree against the defendant to acquire the lands of the plaintiff as per law. E, to pass an order permanent injunction against the defendant defendant not to continue to cause damage to the plaintiff land and crops. F, to pass an order directing the defendant to pay pending interest and at the rate of permissible under law till the payment of compensation. G, the first and any other so and so. This was only this mainly the damage suit was filed, but their claim was that when filing the suit, some land portion of it was damaged by the defendant number 2. In return, this we filed our written statement. This is page 14 of the paper.
Yes.
Basically, our there so many plea was, but basically one plea is there. The construction was under the company.
The construction was under?
Under the company, in
Okay.
Cidas company.
Okay.
But and my ground of the appeal also there. These the construction, there is some norms as per general clause. These whatever they use the land, and they have to compensate the amount. And after all, when contract was signed, they have to verify the portion of the land, how to work and execute, and if any compensation is additional land they use, then they have to pay their compensation. This was the one of the ground. So this in our written statement.
Nothing is mentioned here.
Yes. This page 16. Page 16B. While construction was carried out, the petitioner never filed an objection before DC Scholarship, nor had informed the relay authority. And after ongoing completion of the work, they filed the instance suit for compensation of damage of their land at belated stage. Further, while they mentioned here in the railway construction is carried out by private construction company and not by the railway authority, who are to have been made a necessary party to the case, and hence the entire plaint is defective and liable to be struck down and dismissed on the ground so and so and so. So this was the so thereafter in page 17 of the written statement, these H. There's F is here. The plaintiff has not annexed any documents to prove they are neither photograph of damage of cause of the plaintiff land verification reports from the revenue department. Hence, authenticity of the claim is doubtful, and such enhancement of damage of compensation is strongly objected by the railway. Hence, the claim made by the applicant is liable to strike down and liable to dismiss so and so. H. The joint survey, joint spot verification with DC Scholarship with the presence of all parties are necessary to find out the actual damage caused the plaintiff, if any, while construction of the rail line from Bhairavi to Saira. This is also our ground. Here the case was filed when the award was declared 2012. Then this case was filed 2019. That is also the another point was there. So thereafter, what happened? The district the Planet Court below, directed the joint spot verification.
Okay, so the court for joint spot verification, is it?
Yes.
Where's the distinct judgment?
Yes, yes, this is page 77. Page 77 of the paper. Before that, page 76, that they mentioning today about our written statement. Then thereafter, page 77, plaintiff did not file any objection before the defendant number 1, nor they had informed the railway authority regarding damage. Defendant number 2 further stated that the construction work is carried out by a private company, not by the railway authority, and that the private company ought to be made necessary party. The plaintiff have not made the revenue department as a party in this case. 9. The defendant also stated that the joint spot verification of the all parties is required to find out the actual damage caused the plaintiff. The plaintiff also attached various documents they sought and rely on which they detail annexed thereto. Hearing was conducted on 3/3/2022. Agreed by the parties, it was directed the court that the spot verification, joint spot verification in presence of all parties under the agency of the settlement officer and the revenue settlement officer to be deputed by this settlement officer Kulasip be conducted to clarify as follows. This was the direction of the court, whether defendant number 2, the NF Railway have caused damage to the land of the plaintiff. Here of covered DC pass so and so, all located at Kamrang, Taitun Ram, Kulasip district, Mizoram. B. If so, the area caused to the said land of its if so, the area of damage caused to the said land of each of the plaintiff. This was the two directions. Thereafter, the pursuant to above order dated 3/3/2002, this court joint spot verification was directed by the court was conducted on 19/4/2022. The same was received filed by the SO Kulasip, and this court expressed the appreciation of the prompt action of so and so in compliant direction, names, designation, signature on individual presence, and also it was here to respect so and so. The report was submitted 2/5/2022. The parties have been made aware of the content of the report on 8/6/2022. Joint spot verification report was produced. On perusal of the said report, it was found the plaintiff have valid cause of action of the land damaged by the defendant to the extent verified in the report. On agreement of the both parties, the surveyor conducting joint spot verification was called to give evidence as court. As a court witness, he was called. The parties, in order to expedite the process, to submit produced witness, sought to rely on the joint spot verification findings. It was completely, this order was passed on joint spot verification. There is no evidence adduced by the plaintiff. Neither this court witness was not cross-examined by the defendant also. On 8/6/2022, hearing was conducted on joint spot verification report. After perusal of all documents of hearing, it was ascertained that damage has been caused to the land of the plaintiff. Now the question, what was left to be decided upon the amount of compensation payable to the plaintiff, and it is in this it was deemed most appropriate if assessment on damage cost in terms of money assessed by the district collector's office as is equipped with the requisite expertise and so and so, so and so. Hence the court passed an order on 8/6/2002 directing to make assessment so and so, so and so. So this direction was only on the basis of this joint spot verification report, and when on the evidence of the court witness. Now I'm coming. What was the evidence? Evidence filed by the educed by the surveyor. It is page 43. 43 paper.
Yes.
44 is the type copy. I am on oath. I am so and so. I currently work in surveyor so and so. As per honorable court order, the direction was given for doing spot verification, the settlement of this land so and so. So I was detailed by SO to perform joint spot verification on so and so. Joint verification was performed, and I submitted a group photo. Those who were present that day, I also submit attendance so and so. Therefore, page 45 is the exhibit. 46 is the mentioning all about the exhibit. And thereafter, page 49. This is the report. Sir, as seen the above mentioned order, a spot verification was performed in connection with the complaint on construction performed by NF Railway. I have thus attached the photograph of the people present that day along with the attendance sheet. Complaint was looked into by 3 people, and I have separately attached. Therefore, it is very important word. And I have separately attached my views. This is not report. My views on the respective findings along with the important related documents. I am submitting this report for further necessary action.
So where's the report?
This is the report. They start.
No other documents.
I'm coming. This was on oath. This is the exhibited. This is exhibited. This one is exhibited before the honorable court.
Attendance, page 50 is the attendance.
Yes. Page 50 is the attendance. Now, this 2 is Abhinas Kumar, it's SSC, and this is from railway. And thereafter, there is no date. Yes, there is date on 19/4. Thereafter, the page 51. This as per or receipt so and so. This directed to these are the person to where the settlement officer directed to present on the particular day. And page 52 and 55 and 53. This is the photograph. The person concerned, the photograph of the person concerned, those who are as per the surveyor, they are present. But there is no whisper, there is no written, these people who are these people. Nowhere mention this so and so are the people. They are in the sports spot. This is only the people present. This present is the 5. Here it is more than 5. 1, 2, 3,